examples just of what the language of the statute is, so you can see why it is that I don't believe that the exceptions are enough, that they don't do enough for to protect the kind of research that people need to do. And this is just, here's your example. This is the exception for reverse engineering. And reverse engineering exception is only for interoperability. And you can see all these conditions on it. You have to lawfully get the copy. The sole purpose can be to analyze the elements that are necessary to achieve interoperability. And it cannot have previously been available to you. And then there can be no infringement. So you can see in the way that Congress has chosen to draft these that while you generally are allowed to reverse engineer, and reverse engineering is generally considered to be not a copyright infringement or justified under fair use or something like that. Here, when you're reverse engineering also is a circumvention of a TPM, the right gets very narrow and small. All these factors condition it. Security testing exemption is similarly cabined. It says that you can only claim that exemption for testing that goes to a computer or computer system, and it has to be for good faith, and the owner or operator of the computer has to be the one that authorizes it. So it's very much this narrow cabined thing that you have to that also controls where you can, or to whom you can give the information that you derive from the security testing. So basically, just to kind of sum up this slide, I think if you look at this, I went through all of the exemptions that are listed under the statute and tried to pull out some things that I think are factors that feed into the question of whether one of these exemptions applies, just to give you sort of a sense of it. And I think that it gives me, as somebody who represents researchers and reverse engineers, a real pause about how you condition or plan your research ahead of time if you are a person who's doing research on TPMs, to make sure that you would fit in under one of the exceptions. And I think the conclusion that researchers like Professor Halderman came to is that the exceptions that are granted under the statute are simply not broad enough to cover the types of things that people want to do when they're taking a look at various security issues. So you'll see when we talk about Halderman's exemption request to the Copyright Office exactly that the Copyright Office agrees with him that the security testing exemption is not broad enough, but also disagreed that he gets an exemption anyway. So one thing that I'll also say is that as much as the exemptions might be so narrow for acts of circumvention, they're much more narrow even than that for tools. So if you are a person who is in the business of creating tools that circumvent TPMs, it's a good idea to talk to a lawyer ahead of time, because it's very complicated and very narrow little path for when you're allowed to distribute tools. I'll just say one thing. The tool provision is not about information. It's actually about tools, but it can be components of tools, and so it's sometimes unclear exactly what that means for people who are trying to simply publish research papers. But generally, we like to think that the tools provision doesn't impact speech or publication. That's just pure information. But if you try to communicate your ideas, as computer scientists so often do, in code, then we have problems. If you're interested just more generally in the DMCA, you can take a look at our webpage. We publish kind of a sum up every 3 years about, I think we do it every 3 years, or maybe it's every 2 years, about the unintended consequences of the DMCA and the types of cases that have been filed in the interim period of time attacking things that we think are legitimate research or legitimate efforts. So Congress put in some safeguards in order, because it recognized when it passed the DMCA that this was kind of new and people thought it would really screw up researchers and other sorts of legitimate free speech and fair use activities. So they said, okay, you can have this rulemaking, and this should be the fail-safe. Like the Copyright Office can recommend, and the Librarian of Congress can issue rules that exempt certain things. And basically, you define a class of copyrighted works, say what the technological protection measure is, and if you can show that it fits these statutory factors, including primarily that it doesn't enable any kind of infringement or anything like that, then maybe we'll grant you an exemption for that class of works. And it was in this rulemaking that we recently won, the jailbreaking and the unlocking exception, and the one for non-commercial video. The rulemaking is super complicated in terms of the way that the procedure goes, and the burden on the proponent is really high. And then when you win the rulemaking, if you win, the exemption goes to acts of circumvention. It does not address tools. So that's a very important thing for people to remember. The proponent has to show that for the class of works that you define, the DMCA has had or is likely to have an adverse effect on non-infringing use of that class of works. And I participated in this rulemaking back in 2006 and got an exemption for phone unlocking. This is the class of works that I defined this year as being the one I wanted the exemption for phone unlocking. So the idea here being that you have a handset, it's locked to a certain network, and you want to change it. And some entities, including particularly TracFone, had filed lawsuits against people who are unlockers, claiming that the unlocking violated Section 1201. So how did it violate 1201? The idea was that for, specifically, these lawsuits were about CDMA phones, and specifically for these phones, then when you altered or changed the lock and manipulated the values so that you could put your phone from Verizon to Sprint or some other network, whatever it was, that you were running the underlying software that makes the phone operate, and it's that underlying software which is the class of works. So that's what they argued. Now, where's the infringement there, right? Because this is the thing that I think is so interesting about hardware hacking that's different from a lot of the other copyright issues, which is that there's very often going to be some kind of lock or something that controls how you use the firmware, but there's nothing here whatsoever that has to do with infringement. We're not taking the software off the phone and distributing it on the internet or anything like that. Where's the arguable infringement here? And what the companies have said when they oppose our exemptions is that the infringement comes from your running the software in a way that we don't want you to run it. You're not entitled to do this under the licenses. So I'll show you this a little bit more with the jailbreaking, but you can see. So for the unlocking, we had clients. Our clients were phone recyclers, and we'd identified the copyright work as the software on the phone, and we pointed to the TracFone lawsuits and said, look, there's actual harm. The DMCA is interfering here, and this is non-infringing activity. So we won it in 2006. I was really happy and surprised then, and we won it again this year in the 2009 rulemaking. I know it's 2010, but the rules were supposed to come out in November, and we've been waiting since November for it to happen. So I'm pretty happy if the Copyright Office was going to be late, that they issued the rules right before DEFCON, because otherwise all these slides would just be like a big question mark, like who knows what they're going to do. But look at how they changed my exemption from what I had in 2006. They really, I say they chopped the pinky off of it. They limited it, not to all wireless handsets that you want to put on a different network, but only to used ones. And they put in this word solely that said the circumvention can be solely for the purpose of connecting to a different network. And the operator of the network has to agree, which I'm fine with that. But the reason why I think they did this is because the exemption was opposed by CTIA and also by Virgin Mobile, because those companies, Virgin and TracFone, they sell the handsets with a subsidy at a loss, and then they try to make up the loss by having people go month to month, get the month-to-month service. And what people were doing is that they were going to these big box stores and buying the TracFones and the Virgin mobile phones in bulk, unlocking them, and then reselling them for closer to their true value on the marketplace, and just pocketing the subsidy. And for obvious reasons, Virgin and TracFone didn't like this. It interfered with their business model, which was basically the razor blade model. Then when we litigated this and debated this in front of the Copyright Office guys were like, what do you have to say about that? And I was like, it's not a copyright problem. I'm sorry. It sounds bad, but it's not a copyright problem. It's this is their business model, and they're going to have to figure it out. Maybe they have contract remedies. They have, they can make the big box stores only sell one or two to a person at a time or whatever. And so what they clearly did this is to try to make sure that those bulk purchasers didn't enjoy the benefits of my exception. So what can I say? Okay, so jailbreaking. So this is the one I think a lot of people were really interested in, and which really blew my mind when they actually granted it. This is the class of works that we defined. So do you guys see how like arcane and weird this whole rulemaking is? I mean, it's like this is a class of copyrighted works, and we're sort of like trying to, the description has to be the description of a type of software. So here's what we described it as. It's programs that let you run software applications if the software applications are lawfully obtained. So this is what we asked for, and we tried to cabin it so that it was just going to be about interoperability because we wanted, the Copyright Office to like it and accept it. And what are the copyrighted works that we're talking about with the iPhone? Well, there's the bootloader, and then there's the iPhone operating system. And the question, I guess, was that we had to show, and this is one of these weird political things about doing the rulemaking, is in order to win, you have to show that the DMCA adversely impacts what you're doing, which means you have to say that it's unlawful under the DMCA, except you don't want to say that this thing that you think is important for people to be allowed to do is unlawful. So you have to kind of say, well, it's arguably unlawful, and so the DMCA poses this danger. And then on the other side, you have Apple coming in, and Apple wants to say, oh, don't worry about the DMCA here, there's no harm or anything like that, but they don't want to say it's lawful. So they're in the same kind of catch-22. There's a little dance where, everybody's kind of like suggesting that they believe the opposite of what they wish were true. And so, basically, Apple came in to the hearing and said, we don't think that this exemption should be granted. We'd have engineered the iPhone very much so that we control access to both the bootloader and the operating system. And they gave evidence in the hearing about the chain of trust and how, basically when you boot up your iPhone, there's a cryptographic check on each level of the software to make sure that it is something that is approved by Apple. And starting, from the bootloader and then validating the operating system, which validates the applications, and that this chain of trust is their technological protection measure. And so, we had said, yes, okay, so now we have to show that there's something out there that is going to, that circumvents this, and that this circumvention is legitimate and is in danger. So we looked at and presented evidence about one of the jailbreak tools that's out there and how it works to circumvent the chain of trust, or to basically circumvent the technological protection measure that Apple put on the phone. So, this is basically how one of the jailbreaking tools work, and you can see that this is very interesting. It's a circumvention. So, the question then at that point in the rulemaking for Apple was, well, they have to show that we don't fit in under the statutory allowances for issuing exemptions because somehow or another we're violating copyright law, and the factors aren't met. And this gets to the point that Matt was trying to make about terms of service and EULAs and licenses. One of the things that they said is, well, when you modify the copy of the bootloader that's sitting there on your phone, you have created a derivative work, and that is infringing. So that's thing number one that they said. Thing number two is that when you have the operating system or software on your phone and we issue it to you under a license, you are not necessarily the owner of that piece of software. You're a licensee. And so owners of software have certain rights under Section 117 of the Copyright Act to do adaptations to enable them to enable you to make your software interoperable with other pieces of software. If you're not an owner, you don't get the Section 117 rights. So they said, well, there's no rights of adaptation here that apply. And so when you do adaptations, it's infringement. They also said that the infringement happened from other people, not just the people who were the owners of the iPhones who wanted to jailbreak them. That the people who developed the tools were infringing Apple's software and Apple's copyrights, and that people who made independent applications might also be infringing as well, or at least in violation of their software agreements, whether it be the SDK license or the SDK agreement or other pieces of software licenses. So we had a big argument about this. before the Copyright Office. And